And we're back. Now let's jump into the bulk of the state cases with State v. Lujan. This is a very important case on eyewitness identification testimony, not so much for the facts of the case itself or even the holding of the case, but because it introduces Rule 617 of evidence, which went into effect fairly recently. So let's become familiar with it, shall we? Question in the case: what's the new test for eyewitness identification under the Utah Constitution? The answer takes some explaining. We'll talk about it. But become familiar with new evidence rule 617, especially police officers who are listening to this, because this is going to affect how you do your lineups, how you do your show-ups, how you do any eyewitness identification, essentially. So Kendall Oney was an insomniac who liked to spend nights stargazing. He'd wake up randomly 2, 3 in the morning, and he'd just go outside and look at the sky. So around Thanksgiving 2012, he was up at 3:30 in the morning and the sky was overcast, so he needed something else to do. He decided to work on his car instead. While he was sitting in the driver's seat, Lujan opened up the door and squatted next to him, and he was less than a foot away, so really close. And Lujan said, "Why are you following me?" And Oney was thinking, okay, what's this guy on, right? Excuse me? Lujan reached for his waistband and Oney slowly stood up. He kind of keeps eye contact with him, makes his way out of the car and just goes to his house, locks the door, calls police. Lujan steals his car. But this car was being worked on at the time, so it was leaking fluid all over the place. So they were able to just follow the fluid in the road to find where Lujan ultimately abandoned the car. They found it next to a trail by a nearby elementary school. So they get out the dogs and they start sweeping the area. And one of the sweepers found Lujan curled up in a ball behind an air conditioning unit. So he was hidden really well, right? Kind of like playing hide and seek with my toddler. The officer asked him why he was hiding, and he said, "Somebody is following me." This time he happened to be right. So Oney described the suspect about being 5'10", 180 pounds, Spanish, wearing a black jacket with, quote, longish hair poking out of a beanie. Lujan was in fact Hispanic, but he had closely shaven hair and a goatee. He was wearing a black beanie and a black jacket. So not a perfect description, but a kind of in the ballpark description. Police do a show up about half an hour later and they ask Oney, "Is this the guy?" He says, "Yes, it is." He also identifies Lujan at prelim. Defense counsel requests a photo lineup, and then he picks both Lujan and another person. So a little bit of inconsistency in identification. Defense counsel moved to suppress the show-up and the prelim identifications as unreliable. The trial court denied it, and he was convicted of aggravated robbery. So in order to understand what happened here, we have to talk about another case, which is State v. Ramirez. This was the case on eyewitness identifications under the Utah Constitution for a very long time. So let's talk about it. There, 3 victims were robbed by 2 men as they were leaving a Pizza Hut. One of the men had a pipe, one of the men had a gun. Both men covered their faces, and the victims gave somewhat conflicting descriptions of these robbers. So shortly after this, an officer who didn't know about the robbery saw 2 men walking down the street at about 1 in the morning. One bolted and the other, who was Ramirez, kept walking. The officer stopped Ramirez to talk to him. While Ramirez was detained, the officer hears over dispatch about the robbery and the people they're looking for. So they think, well, we got a guy here, let's do a show up. So they handcuffed Ramirez to a fence and they brought the 3 eyewitnesses there, surrounded him by police cars, put a spotlight on him, like a lot of things that today we might be slightly uncomfortable with. The victims, what do you know, identified him as one of the robbers. So Ramirez challenged the identifications under the Utah Constitution, saying that the circumstances rendered the identification unreliable. Here's the federal test. Identifications have to be sufficiently reliable to be admitted. Unreliability requires 2 things: police misconduct for 1, and 2, an irreparable likelihood of misidentification. So it's a pretty high bar to clear under the federal Constitution to exclude an identification as lacking this kind of threshold reliability, letting the jury make the call. And you can see the factors to consider there: their opportunity to observe, their degree of attention. The state test was the long standard. So for a long time, it became the general practice in Utah to, rather than calling expert witnesses on identification, you would just give them what's called a Long instruction based on a case called State v. Long, where the Utah Supreme Court said, here are the things to consider when you have an eyewitness identification. Here's why they might be unreliable for these various reasons, all that kind of stuff. So Ramirez considered it and said, it's a really close case, but that's reliable enough. And if you've read Ramirez, it's hard to conceive of a case that is not reliable enough because that had a lot of factors that would otherwise go to potentially showing an unreliable identification. So it was a very good test for people who wanted eyewitness identifications. So the Court of Appeals affirmed, this is under, Lujan is kind of an old case. The Court of Appeals decision was back in 2015, and they affirmed under Ramirez, and then Judge Pierce suggested it was probably time for the Utah Supreme Court to revisit Ramirez because the science had evolved, right? So the court said, fine, we're gonna try science, try to update this test for modern times. So first, the court has to decide exactly what Ramirez basis was, because if you read the opinion, it can be read in a couple of different ways. The defendant said, look, this was the state constitutional test. In some cases, including if you read Ramirez, said, yeah, this is the state constitutional test. We argued that the factors were not constitutionally mandated, and other cases supported that view. So there was a little bit of confusion in the cases about its footing. And we also argued, look, the state should adopt the federal standard for various reasons, which requires, among other things, police misconduct. And the court ultimately agreed with us that Ramirez wasn't constitutionally required, and they decided to go in the rule direction to govern this. So at least it's a rule-based thing that if it doesn't work, it's easier to amend the rule than to amend the Constitution, right? But it didn't agree with us about requiring police misconduct. So we'll talk about the factors that it ultimately adopted. That brings us to Rule now 617 of evidence on eyewitness identifications. It's a very long one, so buckle up, folks. It starts out with some definitions. You can go through them there. I won't be too detailed on it. If you do get one of these claims about an eyewitness identification, we do have a couple of cases. One is State v. Hunter from last year and State v. Bowdry also from last year that basically say, because one of the concerns is people are going to see this, defense counsel are going to see this and say, well, whenever a cop identifies somebody, that's an eyewitness identification, right? And that's going to cause a lot more work for jury trials whenever a cop identifies somebody, which is going to be just about every case, right? But those cases, Hunter and Bowdry, the Court of Appeals has said, the Long factors, Ramirez, all this stuff is all about memory and the unreliability of memory. But when you have somebody making a contemporaneous identification, so an officer watching a drug deal go down and then saying, okay, there's that person I saw just do the drug deal, the concerns that animated Ramirez and these other factors don't deal with that situation because it's about how human memory changes. So if you have a contemporaneous identification, use those, or basically a cop identification, use those cases to argue the court doesn't even need to go down this Rule 617 road. That should be helpful to you. We'll start with the overall standard. The fact finder, considering the factors in subsection B, could not reasonably rely on the eyewitness identification. So let's try to find out what reliability means under the rule. Here are factors to consider: whether the witness had an adequate opportunity to observe, what their level of attention was. So was this just something kind of in their periphery, or somebody in a group of people, they were paying attention to somebody else? You know, how much attention were they paying to this person? Their capacity to observe, so how good is their eyesight, their hearing, their whatever that might help them figure out who somebody is. Were they aware crime was taking place? Presumably your adrenaline's going to be pumping a little bit harder and your attention might be a little different than if you're just kind of sitting in a social setting, right? So those are the first factors to consider. It's a long list, like I said. Whether there's a difference in race or ethnicity between the witness and the person. So cross-racial tend to be less reliable in studies than not cross-racial identifications. Length of time that passed, other identifications, whether they heard somebody say this is the guy or not. And then a catch-all for number 9, any other aspect of the identification. So I can imagine maybe some of you have already gotten defense motions on this, but this could be a really long list to deal with. So be prepared for that. And as always, start by reading the rule and seeing what's helpful to consider and what's not. Though with that catch-all, they can basically argue anything. Right? Now we'll talk about some particular identification procedures. There is a savings clause at the end of all this. So if you don't comply perfectly with all of these things, you still might be able to get the identification in, but it's kind of a high bar to clear. So do your best. And we understand that nobody's perfect and that things happen in the heat of the moment, but do everything you can to comply with these procedures to make it easier on us prosecutors. We appreciate it. So thank you for your great work. If there was some sort of suggestive procedure, the eyewitness identification must be excluded unless the court finds that there is not a substantial likelihood of misidentification. So let's talk about the particular things. So here's identification Miranda, essentially. When you have a photo array or a lineup, the court should consider things like, was it done double blind? So the officer who is asking the witness to identify somebody, the suspect, from a photo array, for example, should not be the one who knows who that person is. They should be just as ignorant as anybody off the street on whether that person is in the lineup or who that person is in the lineup. So they can't give verbal or physical cues and kind of subtly point somebody in the direction of a particular suspect. The instructions they give to witnesses, again, this is kind of the Miranda part, just tell them, look, this person may or may not be in the lineup. It's just as important to protect the innocent as it is to punish the guilty. They might look a little differently. Maybe their hair is a little longer. Maybe they have had facial hair and now they don't, or whatever. And regardless of what you tell us here, we're going to keep investigating the case. So these are the kinds of things that you need to sit down and probably just have a little card like your Miranda card to make sure you're covering everything. Have your Rule 617 card, and maybe your prosecutor's office could help you put those together just so you know exactly what you need to tell them and everything will hold up, because we also have to record all the interviews now, right? And it'll be obvious whether or not you complied with these procedures. Now the stage setting rules, you have to make sure that they look reasonably similar. So you can't have, if your suspect is a white male in his 20s, don't have a bunch of pictures of one white male in his 20s surrounded by 5 middle-aged black women, right? Like, you want to make them look reasonably similar to each other. The examples I have here, they don't need to look identical, but, ballpark, make it fairly close what they look like. And that makes it more reliable. Reasonably similar is the standard. I'm sure we will have cases in the future of fleshing out exactly what reasonably similar means. So the way that you do it will influence how we argue it in the future. Make sure it passes the smell test, right? Just look at it and say, is this close enough? Does this seem fair? And then we'll deal with it on appeal as we try to flesh out exactly what all these things mean.
Well, my understanding there has always been that it should be based on the physical description given by the witness, as opposed to trying to find 5 other people that are similar in appearance to your suspect.
Yes, that's a good point.
So
height might not matter as much, right? Just because you can't tell height unless there's a height measurement behind them. You're not going to be able to tell how tall they are. But like I say, kind of pass the smell test on what it looks like, to mix my metaphors. So you also need at least a 6-pack here. 1 photo and 5 photo fillers. Sequential at the same time. I know the science is a little bit mixed on this, whether it's better to show them the photos one at a time or just give them 6 pictures all at once and say, do you see anything here that sparks your attention or your interest? So go with whatever your department policy is, and maybe you might want to talk to your prosecuting agency to figure out what the best practice is there. Looking fairly similar, with a similar process of formatting. So don't have a bunch of different, if you have like a blue background on one, try to make them look, using a driver's license photo or whatever. Use all driver's license photos. I understand that there might be some circumstances where you have to pull photos off Facebook or something. It might be a little different, but try not to have something that makes one of them really stick out, especially, of course, the person who you're hoping they identify. because otherwise you're going to run into some trouble. Use computer-generated arrays where possible, and I don't know what your software is, but I imagine that's pretty readily available. And if you record the lineup or photo array procedures, well, you got to do that now. Documenting witness response. So you have be very specific when you're saying what you saw. Use very rich descriptors to say what the person looked like, whether you timely ask the witness about how certain they were, what they said. I'm pretty sure, I'm really sure, I'm 100% sure, that sort of thing. Whether you refrain from giving any feedback, no, hey, good job, or that's right, or anything like that. Just kind of zip the lip. Just, you don't even, if you can keep from smirking, if they give you what you want, just kind of politely nod and then move on with life. Like I say, these are very stringent controls. I imagine they're not too dissimilar from the kinds of things that you already do as best practices, but again, there's going to be a lot of scrutiny on these from now on.
If it's double blind, then there would be no feedback to give.
Exactly. So one helps the other when you do that sort of thing. Multiple procedures or witnesses, so they're going to consider whether, if there were multiple identification procedures, whether they saw this person more than once, if this person was in a prior photo array that they laid out, and if they did separate identification procedures for each witness that you have, if you shuffled up the people in the lineup, that's going to be something they're going to consider. Okay, so this is my attempt at a summary. Don't rely just on this, but essentially do a double blind. Don't give any verbal or physical cues. Tell them the person may or may not be in there. They need to clear the innocent. The whole Miranda thing I talked about earlier. Just take out your little Rule 617 card. Use at least a 6-pack with similar looking people and similar looking pictures. Computer generated if possible, and take note of all your steps. Record all of the responses, including initial responses, and don't give any feedback. And for multiple lineups, shuffle the pictures around. But again, the best source is the rule. Just be aware that there's going to be a lot of scrutiny on these from here on out. Now, it also talks about show-up procedures. This is for, you're trying to determine whether a show-up is unnecessarily suggestive. And here are factors to consider. Documenting the witness's description prior to the show-up. Again, give very detailed descriptions on what the witness is telling you this person looked like. I know that makes it a pain at the end of the day when you're writing up your reports after a long day at the office or out on the beat. But do the best you can to get everything in there. It helps, of course, if you have a body cam or a recorder with you to make sure you get all those details. Whether the show-up happened at a neutral location as opposed to the police station, or somebody being handcuffed to a fence surrounded by police officers. Whether the suspect was in a patrol car, handcuffed or physically restrained. All of those presumably would make it more suggestive. So if there's a way that you can, sometimes I appreciate that there's not. You might have a dangerous suspect you just barely caught, and this is the best you can do under the circumstances. We get it. Just do your best. But if you can, by all means, please do make it as neutral looking as possible, and let them know again that that person may or may not be the suspect. Whole bunch more factors, if there were two or more witnesses. Don't let them talk to each other. That's pretty elementary police work, right? Separate them out and don't let them say, oh, I think the guy had a goatee. No, he had a mustache. Like, keep them away. Whether the show-up was reasonably necessary to establish probable cause. So did you really need to do this, or did you not? The more you needed to do it, the easier it is going to be for a prosecutor or the appellate prosecutor to defend. So don't do them unless you really need to. Do a lineup later on instead of a show-up. Whether somebody's been presented more than once. Again, these are very similar to the other aspects. And whether the suspect was required to wear clothing worn by the perpetrator or conform his or her appearance. So this is a for instance. Let's say that you do a lineup rather than a show up. This is just a fun little break, and hopefully this works and doesn't crash the system. You're having all of them perform it. A couple more factors: whether law enforcement suggested by any words or actions that the suspect is the perpetrator, and their confidence level, and whether you recorded the confidence level. And often we get the, I am 100% sure, I'm not so sure. You don't see a lot. I don't see a lot of like 75% sure. Somebody's either really sure or they don't know. But whatever it is, put it down. Other relevant circumstances is the gift that just keeps on giving. The court may evaluate an identification procedure using any other circumstances. So again, another catch-all. Be prepared for very long defense motions on this, and nitpicking about all the little differences that probably don't mean a lot. Incidentally, I am on the Evidence Advisory Rules Committee, and I'm on the subcommittee for this rule because the idea behind this catch-all is that if the science progresses to a point where we have greater confidence or less confidence in those other factors, or there's some new factor that comes up that is some game changer, by all means, shoot me an email. Please let me know what it is so I can bring it to the committee and we can adjust the rule as needed, because that's the route the court has decided to go. They're going to have this governed by a rule, and we're going to update the rule as the science gets updated. So if you have something, email me or one of the other prosecutors on the committee, and we'll do what we can to make sure that's taken into account. So to sum up, like I said, the result in this case is almost an afterthought. The rule governs now, they say, and Lujan can't show prejudice because the evidence of his guilt was overwhelming. I mean, the guy saw him a foot from his face with nothing else competing for his attention. He used similar words. He asked the guy working on his car whether he was following him, and then when police arrested him, he said the same thing, right? Why are you following me? So, and the description was pretty darn close. So with all those factors, the court said, this one is fine. But the most important takeaway from this case is read and reread and reread Rule 617.
Okay. That was a little bit gluttonous, John. You did the double sum up. We talked about not doing the double sum up. Okay. You only get one sum up per case.
Oh, I can't help it.
Yeah, I'm sorry. Okay. I want to warn you about this, okay? There's nothing explicit in this video. I ran it past a couple of people to make sure, and they said, this is going to be prosecutors watching, so everybody's okay. I think, based on context clues, that this poor young lady just threw up on this gentleman right before this happens.
Is that an actual sting?
I believe so. Yeah. He knows his rights, and we should all know our rights. And I think Mr. Meese or Mace...
Maese.
Is Maese? Oh, man, see, I wasn't even close. Mr. Maese knew his rights. So what happened here is what probably a lot of us who have done any kind of traffic court have done at some point. This gentleman was charged with a bunch of traffic offenses. He demanded a jury trial. The prosecutor amended them to infractions, and now he challenges that on two bases. Number one, whether the prosecutor has any authority to do that. And number two, whether or not the denial of a jury trial on an infraction is a violation of the Utah State Constitution, Article 1, Section 12. So we're going to address both of those issues.
Oh, so I sped. I followed too closely. I ran a stop sign. I almost hit a Chevy. I sped some more. I failed to yield at a crosswalk. I changed lanes in the intersection. I changed lanes without signaling while running a red light and speeding.
And that's essentially what happened here. He crossed over the double white lines and crossed a whole bunch of lanes of travel without signaling, so he was charged with multiple offenses, HOV violation, failure to signal. At arraignment, they were both amended to infractions. Again, I'm assuming, and it doesn't specifically say, that he asked for a jury trial at that point, and that's why the prosecutor made that amendment. He made a motion to dismiss with the court based essentially on those arguments that the prosecutor lacked authority to do that it was unconstitutional for him or her to do so. That was denied at the justice court level, and he was convicted. He made the same motion at the district court level, which had the same result, denied and convicted again. So, on appeal, he raises two what the court referred to as meaty issues. Number one, whether separation of powers, which allows the legislature to define levels and penalties of offenses, allows a prosecutor to amend charges and change the level of the offense. And number two, whether this code section in this rule, so 7716 and Rule 17D of criminal procedure, are unconstitutional because both of those deny someone the right to a jury trial on an infraction. So this was Justice John Pierce.
That's a pretty good one there.
Hey, thanks. And as you probably figured out by now, that's not Justice John Pierce. That's actually David Morse from the Green Mile. He was also, we made reference to John Adams earlier, he was George Washington in the John Adams miniseries.
That's true.
That's Justice Pierce. Wait, that's not Justice Pierce either. That's actually Neil McDonough, who you may recognize from Minority Report and Desperate Housewives. There's Justice. No, that's Michael Rappaport, who was Phoebe's police officer boyfriend in Friends, and who also starred in Deep Blue Sea, which is classic cinema. No, this is actually Justice John Pierce, who wrote the opinion of the court on the separation of powers issue. Before reaching the question, the city says Supreme Court doesn't have jurisdiction to even hear this. The jurisdictional statute for the Supreme Court of Utah says that in order for the Supreme Court to weigh in on something, it has to be something where the district court ruled on the constitutionality of a statute or an ordinance. And the city correctly argues that that's not the case here, so this court lacks jurisdiction to address this issue. Mr. Maese says that, for his part, says that only the legislature can define crimes and penalties, and therefore it was a separation of powers problem for the prosecutor to do so. And the court ultimately decides that it agrees with the state and it lacks jurisdiction to hear this. What's interesting is that when he's talking about what did occur here, that it wasn't the district court ruling on the constitutionality of a statute or an ordinance, but rather the prosecutor acting under some authority, and the court kind of questions, but I'm not really sure what that is. In fact, it says it does not appear that this practice enjoys any statutory authorization whatsoever. So Maese is left challenging a practice that is apparently justified by notions of prosecutorial discretion. So that might be the next basis for an appeal.
The only way they could get that on a justice court case is if they asked for a writ.
Oh, we'll get there.
Yeah, so I'm sure Mr. Maese will do it, because if any of you know Mr. Maese, he's a professional litigant. I think he purposefully speeds up and down the Wasatch Front just trying to get a speeding ticket so that he can go to court. He's had 2 cases in the Utah Supreme Court that he himself has argued and done actually remarkably well. So he's also a convicted pimp, which makes it fun. That was his first case.
Do you think he's available to do the case law update next year?
We should ask.
We'll see. Anyway, ultimately the court decides that it lacks jurisdiction and invites Mr. Maese, which I'm sure is what he will do, to try his luck under Rule 65B. As to the constitutionality of the rule and the statute, so we have, he says that they deny him his right to a jury trial based on an infraction, and that is a violation of Article 1, Section 12 of the Utah State Constitution. The 2 provisions we're looking at here is, again, 7716, which says that in the case of an infraction, it's going to be decided by a magistrate. And then we have Rule 17D of criminal procedure that says no jury shall be allowed in the trial of an infraction. So, with respect to the constitutionality and the rules on this, Mr. Maese argues that Article 1, Section 12 gives you the right to an impartial jury in criminal prosecutions. And that ends up being the term that the court focuses on and that this whole analysis is based on, is what does the term criminal prosecution mean, and does that include a case where it's an infraction and that there's no possibility of incarceration. I read this and it was long and painful, and I'm going to do a very brief summary of what the analysis was because I like you guys. So the court goes through, as I said, a very lengthy analysis talking about what the meaning of criminal prosecution was at the time that the Constitution was put in place. He talks about having fear of zeitgeist, which I had to look up. Some of you probably know what that means. I'm sure John knows what that means. And essentially what that is the defining spirit or mood of a particular period of history as shown by the ideas and beliefs of the time. So he doesn't want us to get wrapped up in our own beliefs of this time and impose that belief system or that fundamental way of thinking on what was happening at the time. He wants to try and put himself in the mind of somebody who lived at the time that the Constitution was put in place. So we have to try and understand what criminal prosecution means. My essay cites to some case law, but it ends up being contradictory on whether or not the court can look to outside sources. His argument is that the court needs to rely on the plain text and that clearly even an infraction is a criminal prosecution. The court looks to Young, which was its own precedent, saying that they can consider all relevant factors in making this determination, and he really does consider all relevant factors, every single one. The city argues that cases where the feds have interpreted the Sixth Amendment are helpful in this analysis, but the court says that while tempted, they're not going to go in lockstep with the federal government when this is a state constitutional claim that's been made here. He then waxes poetic. When we look to the historical record, we hope that it resembles a Norman Rockwell painting, poignant, straightforward, and easy to interpret representation. But frequently it does not. In some cases, like this one, the historical record is more like a Jackson Pollock, and we find ourselves staring at the canvas in hopes of finding some unifying theme. After studying the colors and lines of the historical record, we find evidence that suggests a narrative.
And Quill, your ship is filthy.
Oh, she has no idea. Find a black light. This would look like a Jackson Pollock painting.
You got issues, Quill.
Gross. So the court goes through a lot of historical sources. He looks at statements made by the delegates of the Constitutional Convention around that time. He looks at decisions from the United States Supreme Court also around that time. He looks at contemporaneous decisions from various state Supreme Courts addressing the issue and found that most of them disallowed juries on some level of minor offenses, and the definitions of minor offenses varied, but the general consensus was that. He also looked to the 1898 Code, which was our country's first attempt to codify the law, in which he stumbled upon Section 241. And that is the section upon which he hangs his hat for this argument. And it says that without the intervention of the jury, except in cases where imprisonment for a longer period of 30 days is made part of the penalty. Or in other words, under that section, you are not entitled to a jury on a case where there is not either a maximum penalty or at least a penalty of 30 days potentially over your head, or what was at that time a fine of at least $50. And they have kind of defined that in the analysis here to be a significant fine. So he says this section, as he went through the history of it, has had a few minor modifications, but nothing substantive until 1983, when the 30-day requirement was changed to any imprisonment. And so no jury except in a case where there is the possibility of any imprisonment or a significant fine. Based on that section, the court concludes that it's clear that at the time of statehood, at the time the Constitution was put in place, that certain minor offenses were not considered criminal prosecutions when you read Section 241 in harmony with Article 1, Section 12, guaranteeing a jury trial on criminal prosecutions. So the issue, though, is where do you draw that line as far as what's going to be entitled to a jury trial and what's not. He talked about making it municipal offenses because that's what was referred to in Section 241, but he said that those have become much broader now and involve some pretty significant offenses in sometimes. He talked about regulatory offenses, which are offenses that are not inherently wrong, but that are still illegal, like speeding or something. But again, he thought that would not be consistent with the historical context, and so ultimately landed on punishment as being what he thought was kind of the cleanest and the most historically sound way. And in light of Section 241, he decided to just go directly with exactly what it says in that section. So the right to a jury trial does not extend to prosecutions where the maximum sanction is 30 days or fewer and or a minor financial penalty. And the conviction is affirmed. There is also a concurrence, though. This is Justice Lee, seen here at some sort of formal event with, it looks like, Olivia Wilde. Wait, that's Jason Sudeikis from Saturday Night Live. There's Justice Lee. He concurred and essentially said, first of all, he applauded Justice Pierce for doing an awful lot of work, and he did, and it was an awful lot of work just to read it. I can only imagine what it would have been to do all of that research. But he thinks it's odd to draw that line specifically at 30 days just because that's what that statute said. He basically says, I would have just said that he's failed to carry his burden because there's a presumption of constitutionality, and where he hasn't been able to show clearly enough that this violated what the understanding would have been at the time, then he loses. And he would have left it at that. And saving an actual drawing of a hard line for some future case where they have more of a basis to do so. They go back and forth, and there's a bunch of arguing and stuff, and he says, well, this isn't based on a constitutional right, it's based on a statutory provision, and those aren't necessarily the same thing, but they should be. The majority says, well, your approach never allows us to make any decisions because there's always going to be some uncertainty built into these super, super old historical records. And he says, again, look, the party seeking to challenge the constitutionality always bears the burden. And so if they can't show clearly what the understanding should have been at the time, they lose. And we fall back onto the presumption of constitutionality. The majority says if this record isn't clear enough, none ever will be. And he says that's weird because this record is actually pretty scant. So there it is.
All right. Time for our annual cautionary tale about jury instructions and making double and triple sure that the instructions are correct. This is a very prominent case, but there are certainly others I could have chosen. Be careful out there, folks. Question: do prosecutors need to be extra special careful with jury instructions and elements instructions in particular? The answer is very yes. Okay, this is a case about a murder of a police officer, Sergeant Corey Ride. We talked about the Court of Appeals version a couple of years ago, so here's the Utah Supreme Court's go at it. This is Jose Angel Garcia Wadegui and Megan Grunwald. He was 27 years old, she was 16. Of course, it's a match made in heaven, right? He was on parole for manslaughter, and she was in high school, and they thought it would be a good idea to hook up. So naturally, Mr. Garcia moved in with Grunwald and her family, and again, not surprisingly, that didn't go so well. Mom liked that Jose helped with rent and groceries, but Dad didn't like that his 16-year-old daughter was sleeping with the 27-year-old manslaughter parolee who was also living at their house. So eventually, Dad told Jose to move out, and Megan said that if he left, she was leaving too because she loved him. Dad slapped Megan, which caused Jose to pull out a gun and threaten to kill him. So again, super functional home life here. This incident and his failure to correct it violated Garcia's parole, so they issued a warrant for him. And when Garcia found out about it, he asked Grunwald to go on a ride with him. So they took Grunwald's truck and she drove. And when Garcia told her about the warrant, she got really upset and they pulled over and turned on the hazard lights and had a little heart-to-heart about his life choices. So Sergeant Corey Ride stopped to assist, and he saw that Grunwald was crying, but she said she was fine. So she hands over her license and registration, but Garcia gave him a false name and a birth date twice. You know, he checked the names like, well, that one's not in there. Let me try again. So he twice lied to the officer. While Sergeant Ride was in his car checking Garcia's information, I think for the second time, that's when Garcia pulled out a gun and told Grunwald he was, quote, going to buck the officer in the head. And this will become important later on. Grunwald put her foot on the brake while the car was in drive, and she held it there for 3.5 minutes as she repeatedly checked the truck's back window, or as she checked oncoming traffic. So when there was a significant lull in traffic, Garcia opened the truck's back window and fired 7 shots. You can see this on the police dash cam. And he killed Sergeant Ride. Though the dash cam caught the entire thing from the perspectives of Sergeant Ride's car, the truck's windows were heavily tinted, so it's not possible to see exactly what Grunwald or Garcia are doing, except based on, you know that she's driving and you can see that the brake lights are on, so you know that she's holding her foot on the brake for a long time. Reasonable to infer that she's checking traffic and waiting for a lull, because that's the exact moment, and you can see when there's a lull in traffic because cars stop going by, right? That's the exact moment that Garcia opens fire. So he immediately takes off. There we go. And when Sergeant Ride was discovered dead about an hour and a half later, of course, there's an APB, go find this truck. They find her driving on I-15 near Santaquin. Grunwald got off the freeway and another deputy, Deputy Sherwood, was following her. She suddenly slammed on her brakes to close the gap between her truck and Deputy Sherwood's car. And Garcia fired again, hitting and seriously wounding Deputy Sherwood. Fortunately, he survived. And Grunwald immediately sped off, returned to the freeway. Once on the freeway, he fired for good measure at a third officer, Trooper Blackenangle, but missed. He also leaned out the window and fired at a semi. So we got about as high octane situation as you can imagine, right? And he hit another car. Grunwald hit another car and damaged her ability to steer and brake, so she had to pull off. And Garcia tells her to go grab another car so they can continue this wonderful chase they're having. They get out of the truck and start running with Grunwald following Garcia. Grunwald flags down a car and gets into the passenger seat. She orders the driver out, but officers are later able to spike the car. They abandon the car and start to run. Garcia, officers eventually shoot Garcia, and when she goes to trial, Grunwald's whole defense was she was compelled to do all of this. She essentially had a gun at her head. She didn't want to do this, but he was threatening her to comply with this. But interestingly enough, right after the officer shot Garcia, she didn't thank police for being her deliverers from this terrible captor. She told them hysterically and angrily at the top of her lungs, quote, "You shot him in the effing head. You shot him, you a-holes. You didn't have to shoot him." So clearly these are the actions of a compelled person, right? But that was the defense. And that'll again become important later on. It was really only a partial compulsion defense because she also argued that she didn't know what he was planning on doing. Because if you argue compulsion, you have to basically know what you're being compelled to aid. But she was basically saying, he was forcing me to do all these things. I didn't know what was going on. It was an emotional time, and I was just racing around and not exactly knowing. And she also said she thought, quote, "buck in the head" meant shoot the car. Huh. Okay. So super believable defense, right? Jury didn't buy it for understandable reasons. He was convicted on 11 different counts. 7 of them, including aggravated murder, involved accomplice liability. So here's the accomplice liability statute. Coupled with the default mental statute, the solicitation, request, command must be at least reckless, but aid has to be intentional because the statute says intentional aid. So different mental states potentially apply to ways in which you aid somebody else to commit a crime, but you have to look at the underlying crime itself because somebody has to have the same mental state as another person under State v. Jeffs, and I guess Idris is an exception, but you have to have the same mental state required for the principal offense. So she had to intend that Sergeant Ride die, essentially, or at least, if it's depraved indifference or whatever it happens to be. She had to share the same thing as she would have had to have in her mind were she the one who pulled the trigger herself, is the basic idea. Now, that doesn't mean that the principal and the accomplice always have to have the same mental state to be guilty of something. If you look at Idris, that was a case where a gang leader called out a green light, a hit on somebody, and there was some testimony that it was, and then somebody went out, what do you know, and killed that person. I think it was a girlfriend of one of the gang members who was also a police informant, or they at least thought that she was a police informant. And he was actually convicted of manslaughter as an accomplice, even because the idea being he was reckless on whether putting a green light on this person would not just cause somebody to beat somebody up or give them a good talking to, but would actually cause them to kill them. So you have to be really careful. If you get one of these mental states with accomplice liability in a big, hairy case like this, feel free to talk it out with us. And we know we're not perfect either because you can never exactly predict exactly how the courts are going to view these things. But read this case and you'll get it why there was a problem here. And part of the issue, too, I think, is had the prosecutors just used the Muji on this, they would have been fine. So there are sources to look at. On appeal, she challenged 3 instructions on accomplice liability that said it can convict Grunwald if it recognized that her conduct could result in committing the crime of aggravated murder but chose to convict anyway. Do you see the issues? That's the standard for recklessness. And aggravated murder cannot be committed recklessly. It has to be intentionally or knowingly, right? the second jury instruction, if it found that Grunwald intentionally aided Garcia, who committed the crime, that should read to commit the crime, because that says that she didn't have to have any mental state at all, just that she aided him. It's like, yeah, I gave him a ride. I intentionally gave him a ride, and therefore I'm guilty of murder. That's potentially how the jury could read that. And finally, the jury could convict if it found that Grunwald intentionally aided and was aware that his conduct was reasonably certain to result in his committing the crime. No, this isn't his trial. He's dead. This is about her conduct and what she thought and her mental state. So there were a few issues with the jury instructions here. She argued in the Court of Appeals that her counsel was ineffective for not objecting to these accomplice liability instructions. And again, these almost always come up in the IAC context, because defense counsel lets you, as the prosecutor, prepare the bulk of the instructions and then just says it's okay. I remember one jury trial that I did years ago, and I presented my draft instructions to opposing counsel, and he didn't even look at them. And I said, "Are you going to take a look at those?" And he said, "Nah, bad instructions never hurt defendants." Basically saying, yeah, I'll just get a do-over and I'll be held ineffective and I won't suffer any consequences for it. So that was very eye-opening to me as a young prosecutor. And a lot of these come up in IAC, and it doesn't matter. If there's a problem with the mental state, the court's going to be bugged by it, and understandably so. I'm not trying to minimize the concern for that. But it means that if defense counsel is not going to be careful and the court's not going to step in and really evaluate these, you need to be super careful. If you have an hour to get ready for trial and you're wondering, should I work on my closing argument or should I work on jury instructions? Work on jury instructions. Just do it. Put everything else aside and work on jury instructions, because that, more than anything else, is going to help secure the finality of your conviction. And if there's a problem in there with the mental state, odds are we're going to lose, unless the evidence is so overwhelming. If you have them on video and confessing and DNA evidence, maybe you want to roll the dice, but they're probably just going to plead guilty anyway, unless it's a death penalty case. And then if it's a death case, you want to be super careful anyway. Again, I can't emphasize this enough.
And if you only have an hour to prepare for trial, you might want to move to continue.
Oh, I meant like the marginal hour. Like you have some free time. Everything else is done. What are you going to do? Don't work on style. Work on substance. Okay, so we actually conceded the instructions were wrong. We just argued lack of prejudice. And the Court of Appeals agreed with us. Chris Ballard from our office did an amazing job, and the Court of Appeals was convinced that the errors were harmless. We thought it was the right results, of course, but again, these cases are never an easy sell, and the courts really, really, really don't like it when jury instructions are wrong, on mental states especially. So the Supreme Court granted cert, and we hoped for another miracle, but that didn't happen this time. All right, this case is legally important because of the way they address the prejudice prong of IAC and jury instruction cases. It could be helpful if you get a motion for a new trial in one of these. You basically ask yourself two questions. We actually think there should be a third step. So here are the two questions. Did the instructions create at least one wrong path to conviction? And then look at the facts and arguments and decide if it's reasonably likely that the jury actually took that path to conviction. We think that's if the answer to the second question is yes, there needs to be a third question, which is there a reasonable probability that a correctly instructed jury would acquit? And we think that's missing here, but the court left it out, so we've got to deal with it unless and until we're able to convince them that they need to add step 3. But again, if you get one of these claims, be sure to look at Grunwald. We filed actually a petition for rehearing on this. I don't think we've heard back on it, so this may change, but something to be aware of if you get one of these claims. The Chief Justice Durant wrote the opinion for the majority. He said, well, maybe they just thought she was reckless, so here's that wrong path they could have taken. And maybe they thought that she could have intended to aid Garcia but not intend for him to commit the murder. Or maybe they thought that she knew Garcia would commit murder but did not know that her actions would contribute to the risk that would happen. And they didn't think that evidence of guilt was all that strong. Buck, they said, is not a common term for shooting, could be reasonably misunderstood, though in the modifier in the head seems to say, what are you going to do? Are you going to kick him? You're going to throw $1 at him? You're going to hit him with a horse? Like anything that Buck could mean. The only thing that you could hit him with from that car is a gun. So I disagree that that's all that ambiguous given the modifier there. But the court didn't like it. or wasn't persuaded by it. So the windows in the truck were tinted, so the only thing that we know from what happened in the cab there is from Grunwald's testimony later. There's nothing to contradict that. It always annoys us when the courts take this kind of tack and say, well, the defense provided this evidence and the prosecution rebutted. It's like, we can't. The co-defendant is dead. The victim is dead. What do you want from us, right? We don't have much to offer here because there's nothing to give. But the court didn't like that aspect of it. And they also said Grunwald has a learning disability. She was very young and impressionable. So, new trial. There was one bright spot here. The court says accomplice liability doesn't require but-for causation. So just because they could have done it without your help doesn't mean that you're not guilty. So I thought that was the right result, and we got that going for us, which is nice. Really quickly, we usually don't spend a whole lot of time on dissents, but Justice Lee's is just too good not to talk about. And he's just kind of incredulous. He says, look, Grunwald admitted that Garcia pulled out a gun and said he was going to buck Ride in the effing head. That's not ambiguous. She knew Garcia had a violent past. Remember, he's on parole for manslaughter, and that he refused to go back to prison. She was upset with police after the chase. She's yelling at them for shooting him, her would-be captor, right? And didn't express relief at being freed from a captor. Her testimony was entirely incredible, given her actions in waiting several minutes and helping him shoot at several police officers. And there's no need for direct evidence. This was the part that we argued when contradicting Grunwald's account, when circumstantial evidence will do just fine. She clearly loves this guy. In fact, when she was in jail, one of her jail letters had a picture of a girl's hand being held by a skeleton hand. And it said something like love forever. Like, she kept assisting him to help try and kill other cops. Like, Justice Lee is just kind of incredulous here. So for what it's worth, we got a really good dissent showcasing our theory of the case. And the majority sees Miss Grunwald as this impressionable young woman. He sees her slightly differently, I think it's fair to say, as do we.
A healthy level of incredulity. We like that. Okay, so this case is about not ever shaking your head or allowing one of your witnesses to shake their head at the trial court. Question here is, once a motion to disqualify has been filed, can the court continue to do stuff in the case? And the answer is no, and counsel does not need to remind the court about that pending motion at any point in the process. Once it's filed, and the court needs to just stop. So here, Mr. Gavette was charged with insurance fraud, and during his preliminary hearing at one point when a witness was testifying, the court looked over and saw that Mr. Gavette was just sitting there shaking his head no. The court was like, WTF is this? Specifically, he interrupted everything and said, your client's shaking his head. He ought to know that makes me think he's lying, so he's a liar, so he shouldn't be doing that. So, okay, go ahead. Counsel did not respond to that, and the case was bound over for trial. At which point, get these both on the same page here. 8 months later, defense counsel filed a motion to disqualify the judge based on that statement that he had made during the preliminary hearing, and the judge ignored that motion. The case proceeded to trial. The defendant was convicted, and then the trial judge retired. So in the post-conviction motions that were heard, they were heard by a new judge who decided that in looking at Rule 29, that it doesn't specifically say that the court loses jurisdiction once that motion is filed. And so even though it says to stop doing things, if the court doesn't stop doing things, if the court continues to sit over the case without addressing the motion, nothing in the rule specifically says that it renders void whatever happens subsequent to that. And so based on that analysis, the trial court denied the motion for to vacate.
Could I hop in just really quickly here? It's understandable, just to defend a little bit of what the judge did. I think it was Judge McVeigh who did this. Defense counsel, when she made the motion, stood up and basically apologized for making the motion and said, hey, this is probably untimely, but my client's kind of upset, so I'm just making the motion, Judge. You know, she didn't press it. She had no interest in pressing it because she thought it was untimely and she didn't want to make it. She was just kind of trying to put on a good show for her client. But even that half-hearted, shoulder-shrugging attempt was enough. It just shows how serious these are. If anybody ever makes one of these motions, just immediately, if the judge doesn't recuse themselves, immediately just say, okay, need to put a pause on this and send it to the presiding judge.
So this case was, the opinion of the court was written by Judge Diana Hagan. That's not Diana Hagan, that's Dolly Parton. That's Diana Hagan. And she is emphasizing the importance of the rule here because the rule is pretty clear about what needs to happen. Rule 29 of criminal procedure is the one we're talking about. And once that motion is filed, the judge shall do one of two things. Shall either recuse him or herself or shall send it to a reviewing judge. And the judge shall take no further action until one of those two things happen. The policy here is that we're trying to keep judges detached. If there's an issue of disqualification, then it needs to be addressed, and the judge either needs to be off or somebody else needs to be making that decision. That this is vulnerable to abuse by unscrupulous parties, and often a short recess is the only thing that's necessary for this to be addressed, so there's really no reason not to just stop and take care of it rather than soldiering on in a case. The state says, no, there's no error here because counsel abandoned the motion, and the error was invited because they really failed to preserve the issue. They never brought it up ever again. There was no objection. Counsel, as John said, acknowledged that the motion was untimely. So other than stating the motion, counsel never made any attempt ever again to address the issue. But the court says requiring counsel to argue further about the motion is kind of exactly what the rule is intended to avoid, of putting counsel in that position to have to not only move to disqualify the judge, but then argue with the judge about whether or not they should be disqualified. So the motion itself automatically triggers all the requirements of the rule, and the motion also functioned as an objection to any ongoing proceedings in that case under the supervision of that judge. The court also relies on a similar rule in civil procedure, which has also been construed to void any action that is taken after the fact. So, in conclusion, just one conclusion. The conviction is vacated, it's been remanded for a new trial, and there were a couple of other issues that were raised, but they didn't get there because this one was dispositive.
All right, and we are 1 minute away from a break, so I think that's a good spot to break. We'll be back in, well, yeah, this is for lunch, so we'll be back at 1:30 with State v. Sanders.